We're here in the matter of Jessica Geisler versus Joseph White. The cause number is 242-011-4408. It's on today for a motion for partial summary judgment brought by the plaintiff, Ms. Geisler, who's represented by Mr. Nelson.
I wanted to review the facts first and then get into the argument. So Joseph White and Jessica Giesler had a relationship several years ago. During their relationship, they purchased 116 Still Meadows, that is the subject of this hearing, as tenants in common. A few years after the purchase, they broke up. After that time,
Can I ask you a quick question?
yeah.
You said when the purchase was made, it was made tenants in common. I reviewed those documents and I didn't take note, and I probably should have. Was there a specific notation there that said, okay, we hereby make this purchase as tenants in common, or is that just the presumption that the property interest was created when two or more people, that it's generally converted to tenants in common?
When it's to two people, I think the law implies that it's tenants in common,
Okay.
unless it's stated something else.
Okay, and that's what you're relying upon, is just the
And that's what I'm relying on.
Okay, great.
But let me just take a look at the deed here. It won't take me too long.
Yeah, I can take a look at that also.
It says Joseph D. White, an unmarried man, and Jessica L. Giesler, an unmarried woman, the following property. If it's with right of survivorship, you have to say that specifically. And when you don't, then the law implies it's tenants in common.
Great, thank you.
Okay. After the parties broke up, Mr. White took the position that Ms. Giesler had abandoned the property and was not entitled to any value of the property. And this action for partition followed. Now, the motion asked the court to determine as a matter of law that Ms. Giesler's entitled to 1/2 of the current equity of the property, which would be the fair market value less the amount of whatever the mortgage is at this point. The ownership of the interest of the property is determined when it's acquired. All of the documents show the parties intended to own the property equally, beginning with the August 9th, 2019 pre-approval letter, which states Joseph D. White and Jessica L. Giesler have a preliminary approval for FHA financing to purchase a home for $285,000. The earnest money promissory note was in both names. The residential purchase and sale agreement was in both names. The addendums to that agreement were in both names. The Wells Fargo Bank loan statement is in both names. The closing statement is in both names and shows that the funds to close are of $18,377.11 are from, quote, Joseph D. White and Jessica L. Giesler without any separation as to the amount that they contributed. And as we just discussed, the deed is in both their names. The objective evidence is that the property was to be owned equally, and the court should enter an order that Ms. Giesler is entitled to 1/2 of the current equity. Now, the arguments of the defendant are these. First, he argues, well, she abandoned the property when she left. Well, the relationship broke up and that happens. But as we indicated in her reply declaration, she offered to pay 1/2 of the mortgage, but Mr. White never accepted that. And that was because he believed once she left, she would have no interest in the property and accepting payments would be inconsistent with that claim.
Can I ask you a question there?
Sure.
As an owner of the property, did Ms. Geisler have the opportunity, authority to pay directly to the lender and not have to worry about going through Mr. White?
She may have, but she was attempting to work through him at that point, and he refused.
Okay, thanks.
Next, he says, well, I made a greater down payment. Well, At this point, there's no evidence of that. In fact, the objective evidence is that both parties paid the down payment together. And then he claims that there's an Iverson worksheet that shows he made most of the contributions. But there is no Iverson worksheet submitted, and his reference to it would be hearsay or at least violates the best evidence rule. But our argument is the contributions do not matter. The percentage of ownership must be determined at the time of purchase. Next, he argues that, well, she's been using the garage with her vehicle and that entitles him to some sort of credit. But first of all, the property is still 1/2 hers. So I don't know why she should be charged for using part of the property that's in her name. Second, as we indicated in the reply declaration, Ms. Giesler offered to remove the items or pick them up at a cul-de-sac, but Mr. White would not cooperate because he did not want some other guy coming onto the property. So that's fine, he can reject that, but I don't think he can now make a claim to some credit against what she's owed because he did not cooperate to remove the vehicle. The reason that my client's entitled to 1/2 of the current equity is that that's the best way to ensure she receives the value of her investment. The payments that Mr. White made since she moved out would simply be offset by the rental value of him having sole ownership of the property. The only way to ensure both parties receive their investment, plus the gains or losses that may have accrued since the date of purchase, is to determine that each is entitled to 1/2 of the current net equity. Once the current court determines that ownership interest, then Mr. Fry and I can calculate what that equity is and proceed with either a buyout from Mr. White or require the property be sold. But the question right now is, what is the party's interest in the property? Thank you.
Thank you, Mr. Nelson. Mr. Fry?
Thank you, Your Honor. So representing Joe White, there are material issues here, outstanding facts. I mean, it sounds like we have a divorce case almost, or a contract case. And in this case, we're looking, I guess, only at the partition statute. And from my briefing, I pointed out that the law has been amended now. The new amendment under RCW 7.54. So the original one was RCW 7.52 is the old, I guess it's really old, 1877 maybe, if I'm correct there. They started this age-old problem. And even back in those days, there's the right of equity and the balancing of equities. In fact, the courts do pay attention to contributions that the different parties make in order to avoid unjust enrichment. And that's consistent as it is today. I just put in the new law because it does set out specifically what I'd like it to apply here, but just by analogy, before any sale is ordered, the court determines the value of the property. And if the court goes through, the appraiser, we're not really dealing with that. I think Mr. Nelson's right. If it comes down to it, we'll either be doing a buyout or, the default, which nobody will want, is the public auction under this old law. But in partition, or even, when you look at CIRs, we kind of talked about that in our response as well. But the court is allowing evidences in on contributions. It's not blindfolded to the fact that parties contributed different amounts. And so by Joe's declaration saying you know, I claim I made, I think he's saying he's made over $40,000 of the payments. That's an issue of fact, and he says he could bolster that with outside evidence, shows receipts, so to speak. But him claiming that is factual basis enough that he's paid most all of it. I think at a trial it'd be pretty simple. The parties may agree on some of the facts because Miss Geisler was out of work and didn't pay for a significant period of time, and then made 10 mortgage payments straight once she got back to work. But this is a case in equity, and it shouldn't be split at the end of 50-50. It's not like an asset, like a stock or something speculative like that. The real estate is unique, and in this case, the evidence is that it's not 50-50. The dispute is the down payment wasn't 50-50. That's a factual dispute. The dispute is the monthly payments on the mortgage weren't 50-50. And, you know, we have a factual dispute whether or not there is a verbal contract or agreement to share equally, or if Joe agreed to shoulder all of the financial burdens or most all of them. And then whether or not they did in fact live up to their agreement and share. And so this is where the abandonment of a mortgage comes in. I think that's a claim that my client feels real strongly about, because there the court is presented with the promissory note, and that's a promissory to pay and be jointly and severally liable under the deed of trust and the risk of foreclosure. And obviously, if you don't pay on that, you're violating your promise to pay, and you're in breach of that. And in this case, the facts are in dispute over the scenario. At his deposition, my client had testified that he came back from camping in August of sometime in 2023, and just noticed that Miss Geisler had moved out and basically abandoned the property, leaving him with the full mortgage to pay monthly. I think the court would need to hear more evidence about this offer to pay, but not paying directly on the mortgage. The mortgage, as I understand, is paid in current by Joe, and so the parties' credit's still intact. It's just how to untangle their different contributions in this case. And we're opposed to the court splitting the investment in half and turning a blind eye to whether or not it's inequitable. It needs to be the balance of the equity. And in this case, we have material facts in dispute regarding how much, not only we don't, each party's bottom line, I guess, is what I'm getting at, Your Honor. We need a trial to show that, rather than using the old partition statute in order to get a windfall gain at the expense of the other person's contributions. So thank you for your time this afternoon, and thank you, Mr. Nelson, for your professional courtesies getting this on.
Thank you, Mr. Fry. Any rebuttal, Mr. Nelson?
As to the claim that he paid $40,000, again, there's no evidence of that. I think before the court can say, oh, okay, let's take that into effect, there needs to be something objective to look at. That would be objectively identifiable. We could look at canceled checks. We could look at bank statements. We could look at a number of things. None of those have been provided here, except the bald statement by Mr. White. The objective evidence is that they intended this property to be owned equally, and that should follow through until today. So I believe my client's position is stronger here, and the court should order that they both have the equal equity as of today. Thank you.
Thank you, Mr. Nelson. Just as a preliminary issue, I just wanted to give notice to both parties that we've been live streaming via YouTube. I think we had received a request from one of the clients so they could watch, and so we did that. And I also believe that I'm not sure if the courtroom door is open or not, but we're complying with the open court doctrine by that live stream. So we're here on the motion for partial summary judgment brought by Ms. Geisler. I appreciate the recitation of facts and the different exhibits that were provided. So I guess the issue that Ms. Geisler asked the court to determine today as a matter of law is that she's entitled to 1/2 of the current equity at the property at Still Meadows Lane. So as I indicated before, I've reviewed all of the pleadings and exhibits and declarations. Just a brief rehearsal, just so it's in my brain as I rehearse this. The summary judgment standard, it's only appropriate when there's no genuine issue of material fact and the moving party's entitled to judgment as a matter of law. Obviously, the court views the evidence in the light most favorable to the non-moving party here, which would be Mr. White, the defendant, and it draws all reasonable inferences in his favor. At this stage of the game, the court does not weigh credibility or resolve disputed facts. So here, there is substantial evidence that both parties were involved in acquiring the property. I think all the purchase documents, closing documents, the deeds, the loans, promissory notes, loan documents, refinance materials identify both parties as unmarried persons and conjoined by an and. Additionally, there's evidence that the title was taken in both names and that Mr. White understood that the parties would take title equally. I think that's borne out by what's been presented at this point. But the issue presented by the motion is, I think it's more narrow than that and obviously more consequential. And the question is whether the court can determine now as a matter of law that plaintiff Geisler is entitled to 1/2 of the current net equity without further factual development or equitable accounting. So at this point, the court concludes it cannot make that decision and determination. That there do remain, at least in this court's mind, genuine issues of material fact regarding the parties' respective financial contributions, including down payment, mortgage payments, and post-separation carrying costs. And I guess if you take into account a declaration of an individual that says, I've paid $40,000 over X number of years, that's a fact that can be taken into consideration and then reasonable inferences therefrom, such as Ms. Geisler left the home in, I think, August of 2023, some month in 2023, and then there's been post-separation payments. So I think that it's notwithstanding there's not documentary evidence to support the statement, I think that the court is entitled to take that fact and take reasonable inferences from it. In addition, there's questions factually and equitably about the occupancy and use of the property post-separation by Mr. White, and whether that use offsets payments that he's made, and whether Ms. Geisler offered to contribute payments that defendant allegedly refused. Those issues, at least in my mind, seem to be material because the case involves a partition. It's a partition action and equitable accounting between co-tenants, as we talked about a little bit before with the questions with Mr. Nelson. So even if the parties hold title jointly or in common, the courts may still need to determine whether credits, offsets, reimbursement, or other equitable adjustments are appropriate before current equity is divided. So today, the court's not deciding that Ms. Geisler lacks an ownership interest, nor is the court deciding that Mr. White is entitled to a greater share or a lesser share. The court's deciding only that Ms. Geisler was not established, at least on this record at this point of the proceedings. She has not established that there is no genuine issue of material fact as to her entitlement to 1/2 of the current net equity as a matter of law. So as a result, the court's going to go ahead and deny plaintiff's motion for partial summary judgment. And I'm open to any questions or points for clarification.
None here, Your Honor. Thank you for your time.
I can follow up with Mr. Nelson on anything else. I don't think we have I didn't prepare a proposed order denying it, and I could circulate one if that's necessary.
Okay. Any concerns with that, Mr. Nelson?
No, I think Mr. Fry should prepare the order. That's fine.
Okay,
Right.
I'll do that and I'll get it to you. And if we can't decide, I guess we'll load it up for presentation, but we'll figure it out.
Okay. If both parties are comfortable with that approach, we can do that. Otherwise, we can set it for a presentation date.
It's up,
Okay.
up to you. I think we're good.
Do you have a preference, Mr. Nelson?
No, I think Mr. Fry and I can probably figure out the order.
Okay, great. I'll look forward to receiving that, and then we'll go from there. And if not, I guess I'll hear from the parties as to a different route.
Okay, thank you.
Thank you. Thank you,
All
Honor.
right. Thanks so much. Have a good weekend.
You too.